Hello, everyone. This is Tom Zuccaro from the Investor Choice Advocates Network, back for SEC Roundup. With me, as always, is my co-board member and the founder of ICAN, Nick Morgan. Hello, Nick.
Hey, Tom.
We've got a great topic today, and we have a great guest. So we have today Brent Baker, a partner with the firm of Parsons, Bailey, and Latimer in Salt Lake City. Hi, Brent.
Hey, Tom.
So let's jump right into this. We're going to talk today about a specific case which Brent is involved in which the judge has issued an order to show cause why the SEC should not be held in contempt for misrepresenting evidence to the court. Now, we may believe that this should be issued, this kind of order should be issued in every SEC case, but it's not. But in fact, it's quite unique. But it was issued in Brent's case. So let's jump in. Nick, why don't you just tell us a little bit about the case and a little bit about the controversy?
Yeah, and this really was a remarkable order. The case is SEC v. Debtbox. Brent represents one of the defendants. Order came out at the end of November, so a little over a week ago. And immediately a lot of people took notice because it's truly remarkable for a federal district court to even suggest holding the SEC in contempt, particularly under the facts of this case. So before we get into this, this case involved the issuance of a federal court order freezing the assets of a company and appointing a receiver. And so for anyone who's been through that, that is a huge court order that essentially stops the business in its tracks, and in most cases ends in the destruction of the business. Now, on the SEC side, you can imagine, just sort of painting a picture here, that they're conducting an investigation. They believe there are some ongoing violations. I'm talking not about this case, but more generally about when they're seeking a TRO. They believe there are ongoing violations. They need to hurry up. They need to run into court. When they do go into court to ask for these extreme remedies of an asset freeze and a receiver in the form of a temporary restraining order, they are able to go into court and get in front of the judge without the defendants or their lawyers being present, which is what happens here. So it highlights the need for the SEC attorneys to be scrupulous in the accuracy of what they're telling the judge, because we don't have the usual scenario, which is inherent in our sort of adversarial legal system, of having someone be able to push back and inform the judge, no, that's not correct. So as happened in this case, and as does happen in SEC TRO cases, the SEC made its case in front of the judge without any defense counsel present, and the judge entered an order freezing assets and entering an order appointing a receiver over the business, which is usually a death knell for business. One thing I will say that is a factor in this case is one of the issues here is that a financial institution closed an account during the investigative phase of this. And that also is quite common and unfortunate. We have lots of clients who are involved in SEC investigations where the SEC has not reached any conclusions about anyone violating any laws. The SEC is clear about that, but they send subpoenas to financial institutions to get information, which they have to do. And often the financial institutions, in my view, overreact and respond by closing accounts. And that's a central issue here, but you can imagine if you're in the shoes of a defendant or a soon-to-be defendant, and your financial institution tells you, oh, we're closing your accounts. And then a few days later, you get, unbeknownst to you, because you and your lawyer were not privy to the court proceeding, you get a court order freezing your accounts, appointing a receiver, and throwing you out of the business. So I just wanted to set that context for this case, because this scenario does happen with some regularity.
Oh yeah, and I remember getting these on the other side of the table. I was at the commission like you guys were I was there for 11 years, and there's this unspoken but true feeling that exists in the SEC staff that they can go in to get a ex parte TRO. I mean, they go in and get this one-sided TRO, they're good staff people. They're not trying to do anything dishonorable, but they all kind of understand at some level that they get deference. They get to slant the facts in their favor, and they'll be given some deference by the court because they're the government. So, Nick, you're right. That's exactly what happens.
Brent, tell us about the case and how you got to the point you are now.
Sure. Started like most cases, informal inquiry, April, May of 22. The SEC filed its complaint in July of 23, so they investigated for a year-ish, year more. And they filed the case, as Nick has mentioned, this ex parte case. They got a TRO, they got an asset freeze, and they got a receiver appointed, an out-of-state receiver too, which that's also bothering the judge. If you read the hearings, this receiver is like a specialized crypto receiver out of the Midwest somewhere, but he's gone, he's done. Once he got this, he's transitioned to everything. So the judge extended one of the things they get. We're talking about TROs, the temporary restraining order. One of the things that happened that was also unusual is this judge extended that TRO or reissued the TRO, I believe 3 additional times without any input from defense counsel, without, just at the SEC's request. I've never seen him just reissue the TRO when lawyers have made appearances. So we filed motions to dissolve the TRO because we raised the misrepresentations, and they're very material. It has to do with whether or not the banks closed the accounts or whether or not the defendants closed the accounts. And it was the banks. Had to do with what, an allegation that the defendants were moving assets offshore. They were not, and that slapped the judge in the face. We had the hearing. Judge Shelby, at our request, dissolved the TRO and issued that scathing, lengthy decision about what exactly, what facts were misrepresented. And it's pretty clear from the order to show cause that, the judge wrote that order to show cause anticipating that the SEC wouldn't be able to come up with satisfactory answers. I mean, it has 133 footnotes and it's 20 pages long. How many times have you seen 110 footnotes on a 20-page order?
Judge wasn't happy.
Yeah, he was not happy. And then, of course, this case is getting lots of public attention. The SEC's expansionist views are just that. They're just their views. So last Friday, it was interestingly enough, and I'm postulating based on tea leaves here, but we got notice last Friday that the Home Office in Washington, D.C., the Office of General Counsel, was taking over for these 2 trial attorneys who so far seem to be having a bad record here. I don't know what's going to happen there, but it's also very unusual for one set of trial unit lawyers to be replaced by the Home Office with a new set. So that's kind of an interesting thing. They made their appearance. There are 3 of them. And of course, in this context, and in the cases the SEC brings, they won't acknowledge this, but there's case law that says they're just like any other ordinary litigant. They don't get special deference. They don't get special credibility points. And I've never seen a federal judge dissolve a TRO, asset freeze, and receivership. I've just never seen it. And I've been doing this. Yeah. We've all been doing this decades. So.
Yeah, that's true. The other thing which is unusual, I think, is you mentioned the investigation was going on for a year, but the commission needs to show a threat of imminent harm to get the TRO. which is hard to reconcile with a year-long investigation.
It is, and a lot of the fact you guys read through the order, but a lot of the facts that they relied on, the judge said, "Oh, though you misrepresented those facts," and they did. I think they understood that typically the SEC as the government gets significant deference
Yeah.
in a case like this, and perhaps they should. I'm not arguing the merits of that, but it troubled Judge Shelby, and
Yeah.
he is not. He's a bright judge. What I don't know, so that's where we are so far. What I don't know is, so we got motions to dismiss, or we've got the motions all granted. We have motions to dismiss pending as well, not only on the Howey test, determine whether these are securities, but other issues as well. And as far as the potential sanctions, I mean, I'm open to thoughts from you guys, but of course they range from dismissing the case to forcing the commission to pay for attorney's fees. And we're speculating here, but all that's possible. And he could craft some other remedy as well. I don't know.
Yeah. Well, when's the hearing, Brent?
The hearing, they got a week extension when they brought in this new trial team. So it is now set for the 21st. So we should have more info then.
Well, we look forward to the result, and hopefully this is a warning bell for all government attorneys who are making representations to the court when they're getting significant relief, which really harms defendants. In this case, apparently innocent defendants. So, Brent, good luck to you. We're all rooting for the right result, and we'll have a follow-up perhaps once we know what the court does. So thanks for preparing SEC Roundup. Nick, thank you. And for everyone else, we'll see you at the next SEC Roundup.